Right. The chairman, Mr. Kenneth Kwok, is late, so let us start our meeting. This is the Bills Committee, the third meeting of the Bills Committee Administration of Justice Miscellaneous Provisions. Let us confirm the minutes first. The minutes have been sent to members. Any queries? CB2, 17, 14, 15. If there is no query, then minutes confirmed. Let us invite the government officials into the room. There are two papers put before members, and we'll ask the administration to take us through those papers.
我哋歡迎呢就有5位嘅政府方面嘅代表，分別就係
All right, may I welcome the government officials. There are Ms. Christine Y, Assistant Director of Administration, Chief Secretary of Administration, Ms. Esmond Lee, Deputy Judiciary Administrator, Ms. Wendy Chang, Assistant Judiciary Administrator, Development Judiciary, Ms. Elaine, Senior Government Counsel, and also Ms. Angie Lee, Senior Government Counsel. Before the meeting, the administration has given us two papers, and they are CB 2, 13, 14, 15, 02, CB 4, 1075. So who would like to take us through the papers, please? Mr. Lee. Thank you, Chairman. First of all, I'd like to introduce the paper on provision of on the matters to appeals in civil causes or matters to the Court of Final Appeal. Members asked for more information at the meeting on the 3rd of June. We have spent some time on collating the information, and now we have provided the details. There are two parts in the paper. The first part deals with statistics. In paragraph 2, the paper listed the requests made by members. That is the information to be provided by the Judiciary Administration. Our proposal to repeal the as of right appeals is not on the grounds of the number of cases, but on the matter of principle. Now, we don't have statistics on outcomes of appeals because the results of appeal caused by various factors, and it depends very much on individual merits and circumstances of each case. Therefore, if we are to look into the statistics, we must take it with a pinch of salt. In paragraph 5, in response to members' requests, we have compiled statistics from 2001 to 2012-13, and they are now in annexes A to C. As for the statistics between 1997 to 2004, we have difficulty in collating accurate and reliable statistics. The second part of the paper deals with the or otherwise ground for lodging an appeal. Members want to know under Cap 484, Section 22(1)(b), what factors are being considered and whether the CFA had explained what such factors were in any precedent cases. Paragraphs 7 to 9 is the overview of the or otherwise grounds. It is the historical origin. Before the 1st of July 1997, the Judicial Committee of the Privy Council is the highest level of court or highest appellate court of Hong Kong. And after 1997 is, of course, the CFA. Now, in dealing with the CFA bill, we maintain the as of right grounds, and the amount of money is raised to $500,000, or rather the threshold was raised from $500,000 to $1 million. As for the or otherwise ground as the basis of appeal, what are the factors under consideration? We discovered a case, President Hui Xiu-wing versus Chiang Yuk-lin in 1968. And we set out the consideration under paragraph 11. The court noted as a proper construction of Rule 2B an implied limitation that circumstances under which leave to appeal to Privy Council is granted must be exceptional. Otherwise, it would be tantamount to asking the Judiciary Committee to function as an ordinary court of appeal. And then in subsequent paragraphs, we describe the factors considered by the CFA in granting the or otherwise grounds. The CFA is not an ordinary appellate court. It is not just a second appellate court. Now, in the High Court, there is the Court of First Instance and Court of Appeal. That is already an appellate court. It's only under exceptional circumstances that leave will be granted.
去到第14段嘅時候呢，其實我哋就
Para 14 reiterates the function of the CFA. The CFA has emphasized that its functions primarily to consider points of law of great general or public importance and not to provide appellants with a platform to debate yet again factual findings made in the lower courts. And that's a very important part of the function of the CFA. The CFA ordinance still maintains the or otherwise ground. And this is only an exceptional cause. It's only in rare and exceptional circumstances the leave will be given.
講到
And we also want to say that at the last meeting, members asked us for some actual cases. So we have dug up our records and we have made an analysis. You can see this from paragraphs 18 to 20. Now, I would like to stress that this analysis is to give members an overview. This is not a detailed and exhaustive list of the actual cases. As for our analysis result, on the whole, there are three kinds of circumstances, and leave has been granted by the CFA and CA either solely under the or otherwise ground or in conjunction with other grounds. Now, the first is that there may be a wrong legal point of view, and this is in Annex D, that is legal error causing grave injustice. We explain what the details are. One of them would be the lower court made a legal error or errors causing grave justice, or the result would have been different had the errors not been made. As for the second category, is relatively important subject matters. These are set out in Annex E. The last one is miscellaneous. These are rare cases. The decisions show that leave under the or otherwise ground has sometimes been granted as a logical consequence to other orders made by the courts, and 2 cases under this category can be seen in Annex F. Maybe I'll stop here and then we can start discussing this paper. Members, any questions concerning this paper? Mr. Ronnie Tong? I would like to say something about paragraph 14. I have different views. Well, paragraph 14 look at things from a technical perspective. I do not agree that this covers all the functions of courts. We are legal practitioners. The most important function of a court is to do justice. It's not about providing the most efficient service. Well, for people who are wrongly judged, the court should do them justice. If we look at the figures in Annex A, they have proven my worry. You can see that you can see the outcome of the pure as of rights appeals. 0104 and 10, only several cases have been upheld. If we do away with this as of rights appeals, does it mean that these dozens of cases would face unjust judgment? Well, this is against the basic law. We understand our criminal system. We rather be lenient than overly strict because we cannot accept even one single case of wrong judgment. Now we've seen that there are so many cases that have been wrongly ruled. So we cannot just look at things from the percentage number. For the person involved, even one unjust case is unfair. I don't understand how come the court would look at things like this, because we are talking about justice. I would like to ask the government, now you are moving amendments. If these amendments are passed, how are you going to handle these cases? Mr. Lee? I do not agree with the member. Well, for repealing the as of right appeals, it doesn't mean that there is no appeal mechanism. It's just that they have to apply for a leave from the Court of Appeal. If the leave is granted, he can still make an appeal. So it will not affect the doing of justice. Chairman, can I follow up? I think the government misunderstands the principle of appeal. If there are special reasons and you lodge an appeal, then there must be great general and public importance if a leave is to be granted. Well, for individual cases, most of them would not have this kind of influence. Chairman, if you argue with me and if you want to sue me asking me to pay you, to repay you the debt, well, this is an individual case. It will not affect the general public. So it would not be that easy to have the leave granted, it's very difficult to convince the Court of Appeal to give you the right to appeal. So many cases will not fall into this category and they cannot meet the relevant criteria. Unless when the government makes the amendments, it also amend the reasons. That is, or other reasons, you can set out more details so that we can accept that even under general circumstances, as long as the Court of Appeal agrees, then we still have an opportunity to lodge an appeal. Then we can consider that. Otherwise, Chairman, if you just close the door completely, you have to prove that this case would have a general influence. Then you would grant the approval. Then I cannot support that. Now we have a paragraph on that, and actually the Court of Appeal as a function to look at these cases. But for 22(1)(b), there are also other reasons. So under the present system, the CFA will look at cases, and these cases may not reach the level you mentioned just now, but if the CFA thinks that there is a need to grant the leave, then under the present system, it can already be done so. And then in NSDEF, these are real cases showing when and such leave have been approved in the past. So our present system can already cope with this issue. Ms. Priscilla Lang, you're in a rush, so please ask your questions now. I would like to ask questions about Annex B and C. For the brackets, it includes the percentage against. I would like to know the figures concerning leave for appeal, or is just the figure of automatic right that you have shown us, or as of rights. And for Annex C, number of applications allowed and number of applications dismissed. So how about the success rate concerning applying for appeal? I would like to know the success rate as well. I also want to make a general comment. I have some experience myself. Well, applying for a leave to appeal, it is not easy at all. In the first part of this year, I have assisted a friend of mine. He's very unhappy that even for applying a leave to appeal, a senior counsel would have to be hired, and eventually his application was dismissed. So for ordinary people, if you want to apply for a leave to appeal, you have to use over $200,000. So if you take these as of right away, is making things more difficult. So for paragraph 13 and 14, you talk about a discretionary power. And I remember in the AJFS panel, I also mentioned this. Do we need more details? Lately, we have heard many cases like this. The person applies for a leave to appeal, and eventually the leave is dismissed. So I think that we should really look at the discretionary power. That is, under what circumstances the application should be approved. In the past, it was done automatically. In the future, it won't be so. So the litigants would have to pay more court costs. So I really think there will be more difficulties. Mr. Lee? For Annex A and B, as for B is the number of civil substantive appeals, including as of rights disposed of in a court of final appeal. Because Annex B covers all civil appeal cases, so naturally they also include as of rights appeals. If you want a breakdown, then you have to look at Annex B with Annex A, then you will know the difference. Because I cannot put too many figures in one table. So for Annex A is a table about successful and unsuccessful rates of rights appeals, and B is all the civil substantive appeals. And for C as the number of civil leave applications disposed of in the court of final appeal, whether it's finally allowed or dismissed, etc. So you also have to refer to Annex B, then you will know the difference. Just now, a member mentioned another thing, that is for other reasons, and you want a breakdown of that. For the design now, for 22(1)(a), it is about cases of great general or public importance. And our wording is like this. Other than these circumstances, there may be other reasons, and you can make such an appeal. By writing so, we have given the CFA the greatest flexibility to handle other cases. So we are inclined to maintain the status quo so that the CFA can have the most flexibility in handling cases. Yes, this is the problem. You talked about the biggest flexibility. Of course, the judge would want to have the greatest flexibility. However, for the litigants, because now you are taking away one of their as of right. So I think we need to have a discussion here. And also, can you provide us with the reference information in writing later? Well, if you think that of rights appeals are wasting the court's time because it accounts for a high proportion, then I would like to know the figures. As Ronnie said, even though it's a little bit of injustice, is our great concern. So I think we need to look at the principle. If the major principles are satisfied, can you say that it's very likely then the leave will be granted? As for information, yes, we can compile information and provide it to members. Mr. Yu Siwing, Chairman. I also have a question about paragraph 14. It seems that the threshold is now higher. If it's higher, well then, when I look at the information provided to us by the government, well, it's about cases over the past decade. I wonder if a comparison can be made. That is, for such cases, if we use the new threshold, and these cases would not have been granted a leave.
Do you have such information? Concerning the threshold, there is no change. The first tier is Section 22(1)(a). 22(1)(a). It's always been there. Now, since we have done away with the as of right provision, so it will remain as the only provision. And members are concerned that people will lose their right of appeal. That cannot be established. We still have 22(1)(b) or otherwise provision. So a leave can be appealed on the or otherwise ground. Now, according to previous appeal cases, some of the cases in the past were heard. In the future, wouldn't have been heard because of this cancellation of a right provision. Have you done any comparison? That's Mr. Tong's concern. With your new arrangement or with your proposal, then these cases wouldn't have been heard. At present, there are cases heard because of as of right provision. He goes to appeal. The fact is that when he goes before the CFA, the court finds the appeal is groundless and therefore the appeal is dismissed. In fact, the CFA has commented on individual cases. If there is a requirement to apply for leave, this case wouldn't have been heard. So to answer the member's question, without the as of right appeal provision, then these cases wouldn't have been heard. But these are not just cases above the threshold of $1 million. In the future, even if the case is above the 1 million threshold, one still has to apply for leave. Our consideration for the 1 million threshold, that's the reason for setting the 1 million threshold. Now, money is, of course, one factor, but what about other factors which in which the court wouldn't have heard such cases if such factors have been taken into account? It seems that there is none of such assessment. Now, you have the 1 million threshold here. And in some real-life cases, the CFA looked into the cases above $1 million threshold. This is an appeal as of right. If there is no as of right provision, when the case is put before the court for application for leave, the leave wouldn't have been granted. So is it really necessary to have this 1 million threshold? Or should all civil cases be on the same level, be treated on the same level, and that is 22(1)(a)? Now, without that as of right appeal provision, then will there be no appeal? Of course not. One can still apply for leave under 22(1)(b). Legal advisor would like to clarify something. Thank you, Chairman. I hope the administration can clarify this. With regard to annexes A and B, does JR cases, or are JR cases included in these all appeals, CFA appeals? We don't have the information in hand. We have to check. We compile the statistics according to civil appeals. I have to confirm that. Do members have other questions? If not, then we move on to another paper. Thank you, Chairman. The second paper deals with the questions raised by members at the second meeting. A, B, and C are the questions raised by Mr. Tan Ka-pil in writing. The letter was referred to us by the Secretary. A, regarding the proposed amendment to align the time limitation on the enforcement of an award or order by the Labour Tribunal with that in other civil claims. He wants to know if such an award or order would be affected by the bankruptcy of the employer. If a claim is still within the time limit, would the proposed amendment enable an employee apply for the enforcement of an award or order of the Labour Tribunal to claim wage in arrears for an employer who has served out a bankruptcy order after 4 years? We want to explain that the amendment of the law is to repeal a certain provision. If there is an order with the Labour Tribunal, then you have to register in the district court within 12-month limitation period. And then you can enforce that judgment. Now we have cancelled the registration requirement. There is no 12-month limit anymore. That is to put the arrangement in line with other cases. The amendment does not do away with the 6-year time limit, and that is any order registered with the district court can only be enforced within 6 years. As for the relationship between this with the bankruptcy ordinance, that's in Part 3. The point is whether the bankruptcy debt is wage in arrears and does not fall within any of the exceptions in Section 32. Section 32.2, where Section 32.2 applies. Therefore, and the employer will be discharged from bankruptcy and is also released from the liability of wage in arrears. This would be in relation to proposed amendment in relation to security for awards and orders. Has the Labour Tribunal ever, in any case, required employees to make security payment? If so, how many cases have been? Furthermore, what are the grounds and criteria upon which the presiding officers require the employees to make security payments? The answer is there is, or there has been, such cases, but we don't have a mechanism to compile and keep such statistics. Therefore, paragraph 7 says that we are unable to provide the data. Under what circumstances will the tribunal ask for making a security payment? We have quoted Section 29, capital A of Cap 25. The tribunal may at any time, either of its own motion or on the application of any party, adjourn the hearing of a claim on such terms as it thinks fit. As for C, how would a case be dealt with if the employer or employee is unable to make the security payment as required by the court? Has the judiciary considered setting up an arbitration mechanism to allow the parties involved to appeal against an order to give security? Let me explain that there is a review and appeal mechanism. Therefore, we don't need an arbitration arrangement as asked for by Mr. Tang. As for D, it deals with amendments to Section 79A of the CPO Cap 221, and that's a live television link. Members are concerned about the security of the AV equipment. We have considered that in order to address members' concerns, we propose in paragraph 15 that we would like to amend the ordinance such that any facilities for the evidence-seeking process by live television link for criminal proceedings should be approved by the Chief Justice. The Chief Justice is not an expert in this area, of course, and how would he deal with that? As we said at the previous meeting, we have a Criminal Court Users Committee, and there are other people who can be consulted, and we will consult these parties, and then we will make recommendations to the Chief Justice on designating the AV equipment or facilities. In paragraph 14, we said that the Criminal Court Users Committee is not a statutory committee, and therefore it is not appropriate to prescribe the law. In the law, the committee's role in respect of the choice of AV facilities. Question E deals with the Chinese version of the amendments to Section 79A of the CPO, and that is about consistency. Therefore, in paragraphs 18 and 19, we have proposed certain amendments to enhance the drafting of the definition of live television link in the Chinese provision, in the Chinese edition. And by the same token, at the last meeting, a member has raised a concern about the alignment, about aligning the Chinese version with the English version. Therefore, in paragraph 20, we also propose a technical amendment, and that does not affect the substantive content of the provision. It's about just the text, a textual amendment. G deals with setting out by way of practice direction the relevant factors that should be considered by district court judges when deciding whether they should deliver the reasons for verdict orally or in writing under the proposed amendment to Section 80 of the District Court Ordinance.
Members want the judiciary to make it clear. That is, when a district judge decides whether he will deliver the reasons for the verdict orally or in writing, what factors will be taken into account. We have thought about members' comments, and also we have done some internal consultation. Now we are going to issue a practice direction setting out the factors that have to be considered by a district judge. Such things would be a reference for the district judge. The judge will look at all these factors before he made a final decision on the most appropriate mode of delivery. And H is about the written copies. One of the focus of discussion is that for the reasons delivered in writing, should it be stated in the law that such reasons must be uploaded onto the website of the judiciary? As we explained at the last meeting, now we have an administrative arrangement and we are already doing this. But members expressed their strong views. They hope that this can be stated clearly in the law. That is, such reasons must be uploaded onto the judiciary's website. We do not object to this, so we are going to move an amendment. And for the proposed Section 80, bracket 6, we would also include this, that is, uploading the reasons online. As for the reasons for verdict in writing, it should also be the same. The oral reasons would be reduced into writing later. So after consideration, we agree that it should also be stated in the law, so as to align the two ways of doing things. This is my explanation, and I'd like to answer members' questions. Members, any questions? If not, I'll ask the legal advisor to say something. Just now, the government mentioned a point, and you're going to amend the bill. So originally it's done orally, and then the oral reasons will be reduced to writing, so that written documents will be given to both parties. It would be put in the court library, and it also be uploaded, right? Yes. Another question is also about district court criminal proceedings. You have a practice direction as to whether the reason for verdict should be delivered orally or in writing. So if the judge does not follow that, would the judiciary follow up on this? Mr. Chair? Now, first of all, this is what we do. Now, when a judge decides on the way of delivery, first of all, he would ask the litigants what they want. Now, we would consider a lot of factors. For example, the length of the verdict, how much time will be taken, or the language proficiency of the litigants. The judge would take all this into account before making a decision. So in the course of doing this, the litigants' wills would have been taken into account. If the litigants are very unhappy after such a consultation, then when we look at the relevant rules and procedures, there is no appeal. It's because this is not a verdict as to whether the relevant person is found guilty. It's just a choice of delivering the reasons for verdict in an oral or written form. So there is no appeal mechanism. But we believe that this is highly unlikely. Members, any questions on this document? If not, then we will continue with the clause-by-clause examination, but the chairman is not here today, and I don't want to go too fast. So let us wait for our next meeting so that he can chair the meeting. This is not urgent, right? Thank you, Chairman. At the last meeting, we have already completed the clause-by-clause examination, except 484. Of course, we'll be putting forward some CSAs, and we still need another meeting. I agree that at the next meeting we can handle all this. Yes, I think that's a better way of doing it. I do not want to handle all this on behalf of the chairman. Date of next meeting, 28th of October, 10:45 a.m. The clerk will check again as to whether the chairman can attend. If there are no other questions, we will adjourn the meeting now. Thank you.